You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, Your Honor.
All right. Thank you. I apologize that it took so long. I know you were up all night. Can you state your name, spell it for the court reporter?
It is Officer Dewante Miller, first name Dejuantee, last name Miller, Miller.
All right. This is position 6, 23 CP 217474. Kurt Sean Thomas, 65 days without indictment. There's a $22,000 good bond as of 4/6 for interference with government property, willful obstruction, ×2, public drunk, simple battery, family violence, 2 counts of cruelty in the third, and willful obstruction misdemeanor. Go ahead, Ms. Patty.
Thank you, Your Honor. Hello, Officer Miller.
Good morning.
How are you today?
Good.
Tired?
Yes.
Well, I understand that. We'll try to keep it as brief as possible. Where are you currently employed?
Roswell Police Department.
And how long have you been employed there?
A year.
Were you employed with Roswell Police Department on April 5th, 2023?
Yes, ma'am.
Okay. And how did you become aware of the accused in this case?
Originally, the night prior, we were out with him at our local Walmart in reference to a separate incident. So once this incident came about, I was able to identify who he was at that time when I made contact with him.
Okay, so this is the second time you've interacted with this defendant.
Yes, ma'am.
Okay, so it's safe to say you recognize him. Is that fair?
Yes, ma'am.
Okay, so in reference to this specific incident on April 5th, how did you get to the incident location? What was the call?
So initially Roswell E911 dispatched it as a domestic dispute. They cashier at our racetrack observed a male in the parking lot that had a fire extinguisher that sprayed another female subject and a juvenile. Once I arrived at the racetrack, I located the defendant along with the juvenile inside of the racetrack.
Okay. Did you have the name of the cashier? You said it was a cashier at the racetrack?
Correct.
Do you have the name of the cashier?
Yes, it would. If I may look in.
Go ahead, please.
The name of the cashier at that time was Daniel Buttram.
Okay. Did you speak to him when you arrived at the location?
No.
Okay. So you said you walked in and you noticed the defendant, a female, and one juvenile or 2 juveniles?
It was 1 juvenile.
Okay. So what was the defendant's demeanor when you got there?
When I initially walked in, I observed him. He had his shirt off. He was consuming an alcoholic beverage.
Do you remember what alcoholic beverage it was?
No, ma'am.
Okay.
He was being very, loud and very boisterous. There were approximately maybe 2 or 3 other people inside the store. So at that point, I asked him to step out of the store.
Okay. So by loud and boisterous, what do you mean?
He was just being very vocal of what was going on as far as his car situation. Told me that his car had stopped and he tried to put it out with the fire extinguisher, and he kept repeating that. So then that's when I asked him to step outside to remove him away from everyone else in the store.
Okay, so you arrive and he's loud, drinking an alcoholic beverage, and you said he said something about his car?
Correct.
Okay, what did he say about his car?
He said that his car was on fire, so he went and got a fire extinguisher and attempted to put the car fire out.
Did you see a car in the racetrack area that looked like it had been on fire?
No, there was a car that was located in the parking lot, but there were no signs of fire.
Did the caller, the cashier, Mr. Buttram, say that a car was on fire?
Not to my knowledge, no.
Okay, so you make contact with the defendant and you ask him to come outside because he's loud and boisterous. What happened next?
I began to talk to him. I began to ask him what was going on. Again, that's when he voiced that he had came to the racetrack. They were attempting to leave initially from the Walmart, and then they were able to go to the racetrack. He said the vehicle caught on fire. I began to ask him, why was he acting the way that he is acting in front of his juvenile, in front of his children. And from there, that's when it kind of it escalated when I began to ask him why he was acting the way he was.
Okay, what do you mean by escalated?
That's when he began to become a little more combative and started yelling a lot more. I told him to, quiet down, and he needed to calm down. And the only reason why we were out on the scene was because of his behavior.
Did he ever threaten you?
Yes, he did. At one point, he said that he was going to punch me in my face.
Did he ever punch you in your face?
No. So after he said that he was going to punch me in my face, as I was talking to him, I observed that he balled his fist up, and then he began to get in a fighting stance. And so from there, that's when I proceeded to detain him.
Okay. When you were trying to detain him, was he detained easily?
No.
Okay. Explain what you mean by that.
So he balled his right fist up. So at that point, I went attempt to grab his right wrist to tell him that he was being detained to turn around. He was able to turn around, but once I attempted to get both hands behind his back, he began to resist. So my partner that was on the scene with me attempted to grab his other arm. We were not able to get him both arms behind his back. So at that point, we escorted him down to the ground. We still had a struggle attempting to place him into detainment. And from there, we had our supervisor come and assist us in getting him placed into handcuffs.
Okay. So you mentioned now, I think there's 3 law enforcement officers who we have here now, right?
Correct.
So were your supervisor and the other officer, were they present when you first arrived on the scene?
No, they were not.
Did you need to call for backup? How did they end up getting there?
So my partner was dispatched. We were dispatched as a 2-man unit. But once I notified dispatch, it was the same male subject we were out with at Walmart. Then that's when my supervisor proceeded to come to the scene.
Okay, so you detained him and placed him in custody, and you said your supervisor and another officer had to put him on the ground to put him into custody, correct?
Yes, ma'am.
What happened next?
As we were placing him into custody, he refused to put his hands behind his back. We were able to get him into handcuffs. He still was kicking. So we had to have another officer that arrived on scene to detain his feet while he was in the handcuffs.
Oh, like the foot restraints?
Yes.
Okay. Okay, after that, what happened?
I requested my supervisor to call Roswell Fire, because during that time, as we escorted him down to the ground, his head did make contact with the pavement. So I told my supervisor to start EMS, so that way we could get him the proper treatment. Once Roswell Fire arrived on scene, he was still combative. He would not allow them to seek medical attention at all.
So you said he got injured. Was he bleeding? Was he bruised? Was it a scratch? What type of injury?
I believe he had a minor scratch on his forehead.
But you called Roswell Fire and emergency services just to check and make sure that was okay, correct?
Yes, ma'am.
Okay. So when Roswell Fire arrived on scene, what happened next?
They attempted to talk to him. As they were attempting to talk to him, he was still combative. At one point, as he was in the leg restraints, he was able to get 1 foot out of the leg restraints. So we had to place him back inside the leg restraints. And from there, Roswell Fire said there was nothing much that they could do, being that he wasn't able to answer any of their questions.
Okay, so did they leave?
Yes. So at that point, once they advised that there was none much that they could do, Mr. Thomas was placed in the rear of my patrol vehicle, and I transported him to North Fulton Hospital.
Okay, so what happened next?
Once he was transported on the way to North Fulton Hospital, Mr. Thomas continued to kick the back of my cage.
What's your cage?
The back seat of the rear of my patrol vehicle. I have a cage that separates myself from any of the offenders that are placed in the back of the patrol vehicle.
Is that typical in all law enforcement issued vehicles?
Yes, ma'am.
Okay.
He continued to kick the window, the partition that separates myself and the offenders. At one point, he did scratch the inside of my window with the ring that he was wearing.
Okay, so this is a law enforcement issued vehicle that you were in, correct?
Yes, ma'am.
Okay. Okay, where did you go?
I transported him to North Fulton Hospital. At that time, we notified North Fulton security to be on standby to have them assist us in removing Mr. Thomas from my vehicle. Once we removed him from the vehicle, he was still at that point combative, was not listening to any verbal commands that any officer was giving him.
What do you mean by not listening? He wasn't following them?
Yeah, he wasn't following any of the verbal commands. At that point, we wheeled him inside of the hospital, and he was placed in a separate room from everyone else. The doctor and the nurse attempted to come and perform medical treatment on him, but he was still at that point being combative, was not answering any questions. At one point, he attempted to bite one of the nurses that attempted to provide medical treatment to him.
Okay. Did he ever, you've described his demeanor as resisting and not following directions, and you said he attempted to bite her just now, correct?
Yes, ma'am.
Was anything else about his demeanor that was notable?
It was really his language continued to threaten, myself and other officers. At one point, we had to, because of how his demeanor was, we had to take the restraints off, and we had to handcuff him to both side hands to the railings of the bed, but also his feet were restrained to the hospital bed as well.
What sort of threats did he make to you and your officer?
He told me when the handcuffs come off that he was going to beat my ass. He told another officer the same thing. He said, take the handcuffs off and I'll beat your ass. And he continued to repeat that throughout the time that we were there.
Okay, so let's go back to the racetrack. The racetrack, was that in Fulton County?
Yes, ma'am.
Okay, was the North Fulton Hospital, it's kind of an obvious question, was that in Fulton County as well?
Yes, ma'am.
Okay, so at any point, did you ever speak to, you mentioned that you first got there and there was something about a fire extinguisher, one female and a juvenile. Did you ever speak to the female?
I did.
Okay, and what was her name?
Her name, I believe, was...
You can take a look at your warrant.
Yes, ma'am. Thank you. It is Shakira Muskelly.
Okay, and what did she indicate had happened?
She indicated that she said that he was under the influence, and she told me that when he gets in the state of mind, she does not like to be around him. She said that they pulled over to the racetrack. He became agitated, I believe in regards to something personal in their relationship. She said she was with the children inside the car. She said she looked up and she saw that he was walking towards her with the fire extinguisher. And she said that he sprayed her with the fire extinguisher. She initially told me he sprayed her with the fire extinguisher and not one of the juveniles.
Okay, so let's go back here. You said, she said he was under the influence. Under the influence of what? Did she indicate what it was?
She said that it was alcoholic beverages.
Did she ever tell you kind of what kind?
No, she just said that he was had been consuming them throughout the day.
Okay, so just now you mentioned children, but initially you said when you arrived, you only saw a female and one minor child. So there were two children?
Yes, the juvenile son was with Mr. Thomas inside of the racetrack, and the juvenile female was with Miss Muskelly inside of their vehicle.
Okay, got it. So we've got two juveniles. I'm not going to have you say their names because they are minors, but we've got one female, one male, correct?
Yes, ma'am.
Okay, did you discover anything else or interview any further witnesses or any other officers about the events that occurred that led you to the racetrack?
No, ma'am. After we were at North Fulton Hospital, my supervisor came up to me and did inform me that that Miss Muskelly did advise him that Mr. Thomas did spray their juvenile son with the fire extinguisher.
Okay. You charged Mr. Thomas with interference with government property, which is a felony, willful obstruction of law enforcement officer, which is a felony. You did that twice. Public drunk, simple assault, simple battery family violence, cruelty to children in the third degree, willful obstruction of law enforcement officers as a misdemeanor.
Yes, ma'am.
And those were all based upon your interactions with Mr. Thomas at the racetrack and at the hospital?
Yes, ma'am.
Okay. Do you know if anyone indicated to you, a witness or a minor, when this or where this incident with the fire extinguisher happened? Like, was it inside? Was it outside?
No. So when I was talking to the victim, Miss Muskelly, I observed at one of the pumps there appeared to be white powder, what appeared to be from the fire extinguisher at one of the pumps.
Okay. Did Miss Muskelly ever tell you if this incident occurred inside the car?
No, she said that it occurred outside the vehicle.
Okay. Did she tell you who was outside the vehicle with her?
No.
Okay. Did the minor child at any time ever indicate to you that he had been sprayed?
No, ma'am.
Did he ever indicate it to any of your other partners or officers?
No, ma'am.
Did he ever indicate to you that either minor child that they had witnessed this defendant spray their mother?
No, ma'am.
Did they ever indicate it to any of the other officers?
No.
Okay. So going back, and you might have already answered it, you said your sergeant told you that Miss Muskelly had indicated that he did, in fact, spray the minor child as well?
Yes, ma'am.
Okay. So I know you said you've interacted with this defendant a couple of times before. Would you recognize him?
Yes, ma'am.
Is he in the courtroom right now?
Yes, ma'am.
Can you please identify him with an article of clothing?
Mr. Thomas is wearing a navy blue V-neck shirt with a white crew neck underneath.
Is it to my right or to my left?
He's going to be to your right.
All right. Let the court, let the record reflect that the witness has indicated the defendant, Mr. Thomas.
All right, record will reflect.
At any time, did Mr. Thomas admit to you that he had sprayed his family with a fire extinguisher?
No, ma'am.
Did he ever give you any facts other than his car was on fire?
No, ma'am.
Is there anything that you learned during your investigation that we haven't covered here today?
No, ma'am.
All right, no further questions at this time.
All right, Ms. Kennebrew?
Yes, Your Honor. Thank you. Good morning, Officer Miller. How are you?
Good morning. I'm doing good.
Okay, and so you stated that you were dispatched to the incident address on a domestic dispute. Is that correct?
Yes, ma'am.
And the original caller was a Daniel Buttram, that's correct?
Yes, ma'am.
And Mr. Buttram, was he an employee of the racetrack that you were aware?
Yes, ma'am.
And you indicated that when you arrived, you did not speak with Mr. Buttram, is that correct?
Yes, ma'am. That's correct.
Did any of your other officers speak with Mr. Buttram?
Not to my knowledge.
And on the 911 call that Mr. Buttram made, did he state that he saw the incident from beginning to end?
Mr. Buttram advised our 911 dispatchers that he observed a male subject spray a female subject in a juvenile. That was the initial call.
Nothing beyond that?
No, ma'am.
And did he state where he witnessed this incident occur from? Like, was he inside of the actual racetrack? Was he outside of the racetrack?
He said that he was inside the racetrack, looking outside towards the palms.
And do you know approximately how far it is from the cashier's vantage point to the gas pump that my client was allegedly at?
No, ma'am, I do not.
Did Mr. Buttram state who was driving the car?
No, ma'am.
Was Mr. Buttram close enough to hear any conversation between my client and the alleged complaining witness?
Not to my knowledge.
And who did you, I'm sorry, strike that. When you arrived and you stated that you saw my client inside of the racetrack, who was he inside of the racetrack with?
He was inside with his juvenile son.
And were they conversing inside of the gas station?
At that point, Mr. Thomas was speaking to, I believe, other people inside the gas station as I walked in.
And are you aware of what they were discussing?
No, ma'am.
So when you arrived, you initially made contact with my client, correct?
Yes, ma'am.
And you stated that you saw him with an alcoholic beverage, is that correct?
Correct.
What was he drinking?
I'm not sure.
How are you aware that it was alcohol?
Based off of the bottle and the can, and I smelled it. He meant as he consumed one drink in front of me.
So he consumed a drink in front of you, but you're not aware of what the drink was, correct?
That's correct.
Okay. Did my client appear intoxicated?
He did.
How did he appear intoxicated?
As I was speaking with them, he was stumbling and being very loud and boisterous.
Was he coherent?
He was.
At any point, did you test his blood alcohol levels?
No.
And my client stated to you that his car was on fire, is that correct?
Correct.
And he stated he used the fire extinguisher to put the fire out, is that correct?
Correct.
Did you ask him where the children were when he used the fire extinguisher?
No, ma'am.
Did you ask him where the alleged victim was when he used the fire extinguisher?
No, ma'am.
Did you ask him if the windows were down on the vehicle when he used the fire extinguisher?
No, ma'am.
When you asked him if he sprayed did you ask him if he sprayed the complaining witness and the children?
I did.
And what did he state?
He stated no, he did not.
Now, when you initially approached my client inside of the racetrack, was he wearing a shirt?
He was not.
And when you approached my client, did you have on your body worn camera?
Yes, ma'am, I did.
And did you preserve that video?
Yes, ma'am.
Did my client ever physically come into contact with you?
No, ma'am.
Any other officers?
No, ma'am.
Did you seek medical attention?
No, ma'am.
Have you contacted the complaining witness since the incident?
No, ma'am.
Were there any other witnesses that saw the alleged incident occur?
Not to my knowledge.
Were there any videos that recorded the incident?
Besides the body worn camera, I'm not sure.
And to be more specific, were there any videos that recorded the incident prior to your arrival?
Not to my knowledge.
Can I have a moment, Your Honor?
Absolutely.
Thank you. On direct, you stated that my client had on feet restraints. Is that correct?
Correct.
The feet restraints were placed on prior to transporting him to North Fulton Hospital, correct?
That's correct.
And so those restraints, you also stated on direct that my client was kicking inside of the vehicle. Is that with the feet restraints on?
I'm not sure.
Okay, so my client did have on feet restraints as he was being transported to North Fulton Hospital, correct?
He did.
And he was transported inside of your police vehicle, is that correct?
That's correct.
And so when he was inside of the police vehicle, he had on feet restraints, correct?
Yes, ma'am.
So when he allegedly kicked inside of the police vehicle, he would have had on feet restraints, correct?
Yes, ma'am.
Did my client also have on handcuffs?
He did.
And you stated on direct that he scratched the window with a ring that he was wearing, is that correct?
Correct.
Do handcuffs typically limit your movement?
They do.
Now, you also stated on direct that my client made a statement that if you take the handcuffs off, he'll beat your ass. Is that correct?
That's correct.
And was this inside of the police vehicle?
No, ma'am.
Where was he when he made that statement?
North Fulton Hospital.
He was inside of the hospital.
Correct.
Now, excuse me, the alleged scratch on the vehicle, did that hinder you from being able to utilize the government vehicle?
No, ma'am.
And aside from speaking with Ms. Muskelly at the time of the incident, did you ever speak with her after the incident occurred?
No, ma'am.
And Ms. Muskelly originally told you that my client sprayed her with the fire extinguisher, correct? Not the juvenile?
That's correct.
And then she came back and stated to your supervisor without you present that he then, or he actually sprayed her as well as the juvenile, correct?
That's correct.
And you stated that you observed white powder at one of the pumps, is that correct?
That's correct.
Was it the pump that my client's vehicle was at?
I'm not sure.
No further questions at this time, Your Honor.
All right. Anything else from the state?
Yes, I have a very brief.
Okay.
Officer Miller, you may or may not know, but did anyone indicate the relationship between Ms. Muskelly and the defendant?
Yes.
What was their relationship?
He is the father of her two children, and they did reside together.
Okay, so
And Your Honor, I would object. Redirect should have been discussed with the questions that I asked. I didn't ask any of the questions as to the nature of their relationship.
I'll withdraw it.
Okay.
You just told Ms. Kennebrew that he was in feet restraints when you were transporting him, correct?
Correct.
So where on your body are feet restraints? Where are they located?
The ones that we use, they are used to be placed on your ankles.
On your ankles?
Correct.
Okay. Are there any feet restraints on your knees?
No.
So just on your ankles?
Yes, ma'am.
Okay. Did you ever offer or indicate to the defendant that he needed to be tested for alcohol, like a field test, a blood test, a breath test, anything like that?
No, ma'am.
You mentioned to Ms. Kennebrew that there was damage to the, I think you said window from a ring,
Yes, ma'am.
but he was in handcuffs.
Yes, ma'am.
Were the handcuffs in front of him or behind him?
No, they were behind him.
Okay. When he was kicking the gate, was there any damage to the gate from being kicked?
No, ma'am.
I think you called it a gate.
Yeah.
Okay.
Yes, ma'am.
Nothing further.
All right. Anything else, Ms. Kennebrew?
No, Your Honor.
All right. Anything else for this officer?
Nothing from the state.
Nothing.
All
from
right.
the-
Officer, stay safe. Get home safe. Okay. Thank you for being so patient. We had to wait on the inmates to get here.
Yes, Your Honor. Thank you.
All right. Careful getting home. All right. Go ahead with argument.
Yes, Your Honor. We'd be requesting that no PC be found on the willful obstruction of a law enforcement officer in the felony. There was no facts or testimony presented today that showed this action arose to the level of a felony. There was no violence offered. We would also be asking that no PC for battery be found because no intent was shown. And additionally, there wasn't anybody to validate whether or not the fire extinguisher was used to spray the vehicle or intentionally to spray the complaining witness. Your Honor, we would also ask for no PC to be found with the government property since the property was not defaced meaning to diminish in function or destroyed. And those would be our arguments, Your Honor.
All right. Ms. Patton?
Yes, Your Honor. In addressing the willful obstruction, that's a felonious willful obstruction ×2. This defendant and was testified by Officer Miller that he stated multiple times he would beat his ass and his officer's ass. That's enough for felonious willful obstruction. For the interference with government property, the statute says destroys, damages, or defaces, or forcibly interferes or obstructs the passage into or from government property. So if you're interfering with it, my reading of the statute is that is enough to qualify as his kicking of the gate to be an interference. For the battery charge, Officer Miller has identified the defendant and he has testified to the fact that the victim of this crime did testify that the defendant sprayed both she and the juvenile child in the face with a fire extinguisher. That certainly is enough to account for the simple battery family violence. This is a preliminary hearing and improbable cause, and I think probable cause has been met for all of the charges that Officer Miller has given to this defendant. Nothing further.
All right. I'll find probable cause and everything except for the interference with government property felony. I think maybe you said it was a scratch. There's a $22,000 good bond. It was in April, but it's 21. Once you take off interference with government property, we'll go ahead and address it. Free trial.
Good morning, Your Honor.
Good morning, Bostic 2.0.
Hey. The defendant has arrests out of Georgia and Oregon. 9 cycles out of Georgia beginning in 2020. It appears he has an open case in Fulton County for willful obstruction of law enforcement officer by use of threats of violence, simple battery against a police officer, another count of willful obstruction and disorderly conduct. The GCIC states that the case has been indicted as of March of 2023. And it looks like he has a second open case in Fulton County for riot in a penal institution. GCIC just states that it has been forwarded for prosecution as of December of 2022. His last arrest was a failure to appear out of Rockdale County, March of 2023. No disposition listed for that arrest as of yet. The defendant has 2 arrest cycles out of Oregon. Last arrest was July of 2021 for assault in the 4th degree and disorderly conduct in the 2nd degree. It appears the disorderly conduct was dismissed and the assault in the 4th degree, he took a guilty plea on that one, August of 2021. And the GCIC does indicate that he has a warrant dated April 3rd of 2020 out of Bossier City for a stolen vehicle. Nothing to add, Your Honor.
All right.
Is Bossier City in Oregon? Or is that a whole different
So
state?
it's Bossier, actually it's Bossier City, Louisiana. It has a LA in front of the, I'm assuming it's Louisiana because it has a
Right.
LA in front of the, I guess the identifying arrest number. It has LA and then a number after that.
Okay, so 3 states, Georgia, Oregon, Louisiana.
Right.
Got it.
So he hasn't been arrested in Louisiana yet. So that's why history didn't come up for Louisiana, but the GCIC indicates a warrant out of Bossier City in Louisiana.
Thank you.
You're welcome.
Go ahead, Ms. Kennebrew.
Yes, Your Honor. Mr. Thomas is 29 years of age. He has been in Georgia for the past 3 years. He does have a valid address here in the Atlanta area. He is the father of 2. He does have family here in Georgia as well. He did graduate from high school. He was employed prior to being arrested, and he was working with People Ready for the past 3 years. We be asking for a bond not to exceed $10,000, Your Honor. Mr. Thomas is indigent and he is presumed innocent. He cannot afford a bail. He has been in custody now for 65 days.
Yes, ma'am.
Without being able to make his bond. So again, we're asking for the bond not to exceed $10,000, reminding the court that the bond is to prevent punishment before a conviction and to secure the appearance of this person in court for trial. And his financial resources and obligations are to be considered when setting bonds. So again, we'd be requesting a bond not to exceed $10,000.
Is he still going to live on Archer Way? I mean,
Yes,
that's
Your
where but that's where the alleged victim lives, Miss Muskelly.
She moved, Your Honor.
Okay. All right. What says the state?
Your Honor, this defendant has received a bond, which is his right. We believe the bond is more than fair and reasonable, considering this defendant has multi-state offender, as recently as 2021, had a charge in Oregon for similar-esque charges. We believe this defendant is a flight risk and a significant likelihood to reoffend. This defendant has 9 cycles since 2020 in Georgia alone, and believe he's a significant likelihood to reoffend or commit an additional felony while out on bond. The state would ask that you keep the bond the same. However, if Your Honor is inclined to lower the bond, we ask that it be no less than $15,000, with the conditions of no contact with the victim, but using a third party, I guess, for trading children, and a stay away.
Okay. All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 420 East Crossville Road. That's the racetrack. Also stay away from 3000 Hospital Boulevard in Roswell unless he's there for treatment. No further contact with Shakira, Shakira Muskelly, Muskelly. No further contact with Eric Jones. No further contact with Daniel Buttram, Buttrum. No further contact with the 2 juveniles, CT Jr. and RT. R as in Roger, T as in Tom. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. You have 48 hours to have that ankle monitor placed on your ankle if you get picked up on a hold somewhere, sir. And
Your
also
Honor.
that'd be basic life necessities.
That's what I was going to request.
Okay, yeah. I'm kind of trying to get used to putting that in my little spiel. I get so used to saying the same thing over and over again. Also, no further contact with Officer Lowenthal, Lowenthal, Sergeant Hansen, Hansen, and Officer D. Miller, Miller, unless it's in their official capacity. So count 1, the interference was dismissed. The I'll leave the two felony obstructions at 1,000 apiece, 500 public drunk, simple assault, 3,000, simple battery, 3,000, simple battery, 3,000, cruelties, 500 apiece, and the obstruction, 1,000. So that's 1,000, 1,000, 500, 3,000, 3,000, 3,000, 500, 500, and 1,000. Best of luck to you, sir.
Thank you, Your Honor.
Did anyone happen to do the math on that?
I didn't do the math, but I could control the numbers again. You can write them down.
Yeah.
1,000, 1,000, 500, 3,000, 3,000, 3,000, 500, 500, 1,000.
Thank you, Your Honor.
So I think, do we have any other officers that worked late or any officers that didn't show up that we need to go ahead and like get like Ms. Correa's person if we can, at least get the inmates out?
I can either or. I can do Ms. Correa's person, or we can kind of go through who I'm going to ask for a reset on.
All right,
With Judge Ingram, so I'm here until I'm dismissed, Your Honor.
all right. So which officers are we missing to start with? And maybe we can,
For position 4, Officer Buckhart, and again, this is the one who indicated that he either broke his foot or his leg, but he did not give me anything official, so I don't want to misrepresent to the court. I would be asking for a reset.
And Your Honor, I would be in opposition of a reset. This has been reset and it was reset from May 23rd of this year. So we will be asking for a dismissal for warrant of prosecution.
and that was all, was that for officer appearance, do you? Let me
Yes,
look.
Your Honor, it was for officer appearance.
Broke his leg or his foot?
Yeah, I think that it's still injured. And just to be honest, I don't remember if it was his leg or his foot, but it was an injury that he indicated to my investigator.
So let me ask you a question, Ms. Patton. So if that, or officers, I mean, like, some attorneys appear via Zoom. Do y'all not let them appear via Zoom?
Your Honor, I'm not certain to the answer to that question, so I don't want to misrepresent anything to the court.
What's he have right now? He's got,
And Your Honor, we would object to the officer appearing via Zoom.
they didn't send you a note yet, right? Is he APD?
He's
South Fulton.
South Fulton. He's already got $1,000 bond. What's the it's 177 days. What's the status? Well, I'm gonna ask you what the status on the indictment is. You're probably gonna say you don't know, but do you know the status on the indictment by any chance?
Nope, but Your Honor, I would consent to a UJR.
So you said you would?
I would.
So Ms. Kinnebrew, here's kind of what I think I've done this with Mr. Cazzoli or somebody before. A couple of things. One, I can do the dismissal for the officer not appearing, or I can do a UJR.
Your Honor, we will
So
be
if-
requesting, I'm sorry.
So if they do the arrest warrant, they won't go back and pick him up. So then he would start back. We'd probably be in there another 177 days.
And Your Honor, we would still be requesting a dismissal for warrant of prosecution. The officer did not appear. He did not give a legally valid excuse as to why he is not here. We are here and ready to proceed. This is the second time that we have been before you. The reset is from May 23rd. So again, we would just be asking for a dismissal.
Do you want to bring him out real quick, or can we just go ahead and rule? Ms. Kinnebrew.
Oh, we can bring him out.
All right, do you want to get Arthur Myers really quickly? And then what about the officer in position 5, Miss Patton? For Taurus Kelly?
Give me 1 second. Well, he's not present,
Okay,
first and foremost.
all right, we'll address that.
And, okay.
And Your Honor, I just realized, position 8 needs a Spanish interpreter, and I do not see a Spanish interpreter here.
Yeah, we can't ask Miss Correa to double up today, but Ambria, can you call Mr. Carlos, or I forget the other lady's name,
Yes, Judge, I can.
the new lady?
I don't have the new lady's name or information, but I can call Carlos.
Okay, all right, you Mr. Myers?
Yes, ma'am.
Thank you, sir. All right, it's 22 CP 214663. Arthur Lee Myers, 177 days without indictment. There's giving false information, law enforcement officer, and willful obstruction. There's already $1,000 good bond. So since we didn't have you out here, the state will go briefly and we'll take care of this and get you out of here, Mr. Myers. Go ahead, Ms. Patton.
Your Honor, the state would be asking for a reset to see if we could extend so that Officer Buckhart, or Burkhart, I might be mispronouncing it, Sergeant Buckhart can be present.
All right, go ahead, Ms. Kennebrew.
Your Honor, we will be requesting a dismissal for warrant of prosecution. This is the second time that we have been before the court without the officer showing. The officer did not give a legally valid excuse as to why he is not here. This case was reset from May 23rd, 2023, when we were prepared and ready to proceed. Today, we are prepared and ready to proceed, and we're asking for a dismissal for warrant of prosecution.
All right, so I'm not saying the officer didn't have some sort of injury, but I do wish that he or she would have shown something so that we could have reset this. Mr. Myers, there's $1,000 good bond. I'm going to go ahead and dismiss this for warrant of prosecution. I will tell you, Mr. Myers, that I offered Ms. Kennebrew a unsecured judicial release bond in lieu of dismissing it. And that way, once they indict it, maybe they won't come back and rearrest you. But she, which is any good defense attorney did, said she wants it dismissed. But Ms. Kennebrew will let you know that if they go back and indict, they can come back, issue a grand jury warrant and rearrest you. Okay?
Yes, ma'am.
All right. Best of luck to you, sir. So we'll dismiss for warrant of prosecution. But like I said, it doesn't mean that they can still indict the charges. Okay.
Yes, ma'am.
All right. Thank you. LT, you want to get Taurus Kelly?
Okay.
I think this was the first time it's been on. Let me pull it up.
I think this is the first time too, Your Honor. I'm looking now.
Yeah. So if this one, of course, I haven't made my mind up, Ms. Kennebrew. If it hasn't, do you still want to address bond? It's a $50,000 good bond as of April the 6th.
Yes, Your Honor.
Okay. Ms. Watts, what is the reset date for any that we reset so that Ms. Kennebrew and everybody else can check their calendars?
June 22nd at 9 a.m.
June 22nd. So that's reset dates for anybody. Ms. Kennebrew, I don't know if you want to check your calendar if you have vacation plans.
Yes, Your Honor. Good morning.
All right, you're Taurus Kelly?
Yes.
All right, this is position 5, 23 CP 217436, Taurus Shane Kelly, 65 days without indictment, $50,000 good bond as of April the 6th, 2023 for aggravated assault. Go ahead, Ms. Patton.
Yes, Your Honor. The state will be asking for a reset, one-time reset for this case. I believe the date you gave was June 22nd, which would be agreeable just so that we could locate our officer. He was subpoenaed, Officer Commerce. So just enough time to get him here and see what was going on.
Let's see. Ms. Kennebrew?
Your Honor, we'd be objecting to a one-time reset. The officer has not appeared. The officer was properly subpoenaed and did not give a legally valid excuse as to why they are not here, Your Honor. So we would be requesting a dismissal for warrant of prosecution.
All right, this is APD, so I'll send my email and we'll give one-time reset. Madam, Ms. Hollenbeck for officer appearance only. So, Mr. Kelly, I reset this once for the officer to appear. All right, if he fails to appear, then it may be a different situation. And it'll be June 22nd at 9 a.m. Ms. Kennebrew, did you look and that's okay with you?
Your Honor, I'm actually in first appearance on that date.
Oh, okay. Ms. Watts, is there another? You'll be in first appearance that whole week, Ms. Kennebrew?
I'll be in first appearance just on that Thursday.
Oh, okay.
Okay, can you,
I'm sorry, my colleague just said he'll cover, so it's fine.
Oh, okay.
Thank you.
Okay, so it'll be June 22nd at 9 a.m. But we'll go ahead and hear from pretrial and talk about bond. Pretrial.
Our defendant has 13 arrest cycles beginning in 2004. He has one felony conviction outside of the 10-year period. see, he has a felony conviction for aggravated assault and burglary. Disposition date on that is April of 2013. He has another felony conviction out of Fulton County. Well, I'm sorry, not a felony conviction, but a probation. Let's see, 1, 2, 3 violations of probation. 1 FTA. And his last arrest was in Fulton County, October 2019, for simple battery against a person who is 65 years or older, or who is pregnant at the time of the offense, and aggravated assault. It appears the simple battery against a person who is 65 years old was transferred to state court. No other disposition is listed for that ag assault.
Okay.
Yep.
All right.
That's
Go
it.
ahead, Ms. Kennebrew.
Yes, Your Honor. Mr. Kelly, is as stated by pretrial, his last arrest was in 2019. I believe I heard 13 cycles with 1 FTA. He is currently 39 years of age. He does have a valid address here in the city of Atlanta, where he can reside. He is a lifelong resident of Georgia. His entire family lives here, to include his mother, his brothers, his sisters, his aunt. So he does have a good support system. He did graduate from high school and also attended Atlanta Metro for medical assistant studies. He was employed prior to being arrested with DMC marketing firm. And he was marketing products there. He does have some MH issues, Your Honor. We would just be asking for the bond not to exceed $20,000. It is currently set at $50,000, which is substantially high for this defendant, Your Honor. He is indigent. He cannot afford bail. He's been in custody for 65 days with no way to make income or bail. This incident did occur in 2021, and I'm not certain that any contact has been made with the alleged victim. He doesn't know the alleged victim, and so again, we will be requesting, I'm sorry, I stated a $10,000 bond, Your Honor, on this charge.
All right. Yeah. See, the incident date, September 2nd, 2021. Go ahead, Ms. Patton.
Yes, Your Honor. The state would object to a lowering of the bond. This defendant has been provided a bond, as such is his right. This defendant is a danger to the victim, Milo Bridgers. He also, in his history, I believe pretrial mentioned that there was other violent charges in his history. That being said, this defendant poses a significant likelihood to reoffend and a danger to the community. If Your Honor is inclined to lower the bond against the state's objection, state would ask that it be no less than $35,000 with an ankle monitor with 24-hour curfew, with the exceptions of legal, medical, and basic life necessities, and no contact with the victim, Milo Bridgers, and a stay away from the incident location. Looks like it was on top of a hospital.
Okay.
Yeah,
All right.
and I just want to correct the record. The felony conviction from 2013 is actually an aggravated stalking and burglary, not ag assault. It's an aggravated
Okay. All right.
stalking.
No drugs unless prescribed, no alcohol, no weapons. Stay away from 80 Jesse Hill Drive in Atlanta, Georgia, unless you're there for medical treatment only. No further contact with Milo Bridgers, Bridgers, or Christopher Riley, Riley. You have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. Also, basic life necessities. $25,000 good bond. Best of luck to you, sir.
All right.
Thank you, Your Honor.
All right, let's see. What about position 7? Is that officer here?
Your Honor, this is the one I indicated that I didn't get anything official, but I did hear that he might be on vacation. But again, I didn't have anything in writing, so I don't want to misrepresent to the court. Your Honor, the state would be asking for a reset so that the officer can be present.
All right, we'll bring out Antonio Jackson. We got Ms. Gowdy. This looks like, Ms. Gowdy, it's a $10,000 split bond with UJR wraparound services, right?
That is correct, Judge.
Okay. All right, Mr. Jackson, it's a 23 CP 217476, Antonio Jackson, 65 days without indictment. There's a $10,000 split bond as of April the 6th, 2023. Possession of firearm by a convicted felon, possession, purchase, manufacture, distribution, sale of marijuana, possession of methamphetamines, and possession of cocaine with intent to distribute. Go ahead, Ms. Patton.
Yes, Your Honor. The state would be asking for a one-time reset for this defendant so that we can get some information from my officer to determine where he may have been. He was properly subpoenaed. However, this case, I don't think has been in front of a preliminary hearings before, so we would be asking for a one-time reset.
All right, Ms. Gowdy.
Basis for him not appearing in court today? Was he sick or something?
He mentioned, but nothing in writing officially, that he was on vacation, but because it was official, I don't want to misrepresent to the court.
Well, Your Honor, we would object to the one-time reset because there was nothing in writing and no valid reason for him missing court today, Judge. Also, I do have a conflict for the reset date of June 22nd. Judge, I did file leave into all of my SC cases. And so we'd be asking for a June 29th reset date if the court is not amenable to dismissing the case at this time, Judge.
All right, I'll give a one-time reset for this officer to appear, one time only. Is the 29th good, Ms. Watts, for Ms. Gowdy?
Yes, Judge, it is at 9 a.m.
9 a.m., Ms. Gowdy?
Yes, Judge.
That's in June, correct?
Yes, ma'am.
Okay. 6/29.
And this is a Georgia State officer, right?
Yes, that's
Yep.
correct.
All right. It's a $10,000 split. Do you want to address it, Ms. Gowdy?
Briefly, Judge.
All right. Pre-trial.
Your defendant has 10 arrest cycles beginning in 2015. Last arrest was out of Clayton County, March of 2022 for willful obstruction of a law enforcement officer misdemeanor. No disposition is listed for that case. He has a felony conviction out of Henry County for burglary in the first degree, carrying weapon without a valid license, theft by receiving stolen property. He received first offender treatment on that case, April of 2019. His first offender status was revoked March of 2021. He has another felony conviction out of Henry County for theft by receiving stolen property. Disposition date on that is April of 2019. The defendant has one violation of probation and one FTA. It appears GCIC appears to have an active warrant out of Decatur for damage to property. Warrant is dated March 18th of 2023. And then also another active warrant out of McDonough for a probation violation. That warrant is dated August 25th of 2021. Nothing to add, Your Honor.
All right, go ahead, Ms. Gowdy.
Yes, Judge. Before the court is Mr. Jackson. He's 23 years old, Judge. He's a lifelong resident of the state of Georgia. He does have a good address. That address is in Henry County, Judge, not in Fulton County. To my understanding, Judge, he finished high school, has 2 children, has family here, will be living with his sister if released on bond, Judge. I understand the recitation of the criminal history, Judge. My understanding that Henry County probation was a first offender and it's still intact, but I will check again to see if that first offender was revoked, Your Honor. But essentially, Your Honor, he has a nonviolent history in its totality. The allegation in the case before the court right now is he was smoking a blunt of marijuana, Judge, and that led to his eventual arrest, Your Honor. The bond is a $10,000 split bond, Judge. We are asking the court to consider bond as follows, keeping the UGRs to the same. And the bond on the firearm is $10,000. We're asking a reduction to $5,000, Judge. We do believe that that amount he will be able to post bond and go to the 3 other holds. He has a hold out of Clayton County, Henry County, as well as DeKalb, Your Honor. And so he'll have to address business in all 3 of those cases. I do note for the court that in DeKalb and Clayton, those are both misdemeanor warrants, Judge. And the warrant in Henry County, per the warrant, they say they were not going to transport him on that warrant, Judge. So that is a request for bond at this time.
All right. What says the state?
Yes, Your Honor, the state would object to any lowering of this defendant's bond. It looks like he only has a $10,000 bond as indicated by his attorney on the possession of a firearm by convicted felon. He's entitled to bond and such has received a bond of $10,000, and that is more than fair and reasonable. This defendant is a significant likelihood to reoffend, as is suggested by the fact that he's a convicted felon and is well aware that he's not supposed to have a firearm, and a firearm was found on him. In addition to the fact that he has 10 cycles and his last arrest was March of 2022. If Your Honor is inclined to lower the bond against the state's objection, we ask that it be no less than $8,000.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 38 Broad Street. Stay out of Fulton County unless you're here for court. See your lawyer or to participate in any of the pretrial wraparound services. Got that, Ms. Hollenbach? So court, lawyer, and participate in any wraparound services or any program that Ms. Gowdy gets you into. You have an ankle monitor paid for by the county with that 24-hour curfew. Court, lawyer, medical, employment, participating in pretrial, and basic life necessities. I think I already said no drugs, no alcohol, no weapons. Sorry. Doing this remotely, so I'm kind of out of my element today. So we'll reduce it to, we'll keep the other ones at the UJR with wraparound services. I think they did that at first appearance and a $5,000 good bond. Sir, you'll have 48 hours to have that ankle monitor placed on your ankle. So once you get finished with DeKalb in Henry County, you'll have to get back in touch with the ankle monitoring company and have that ankle monitor placed on your ankle. Best of luck to you, sir.
You said 5,000 on the firearm, Judge?
Yes, ma'am.
All right, thank you, Your Honor.
All right. Okay. Thank you, Ms. Gowdy. Have a good one. So what about, is the officer here for D'Angelo Turner?
Yes, she is.
All right. Is there any other officer that like worked overnight that I need to hear before?
I don't know if anyone worked overnight. I'm sure they all just want to go. But I don't know that any of them. Did you work overnight, Sergeant Harris? Oh, well, Sergeant Harris has, and she's up first. I do have a question, Your Honor, regarding position 8. I believe Ms. Kennebrew indicated that he would need a Spanish interpreter.
Right. Miss Watts is trying to get in touch with the interpreter.
Okay, understood.
The deputy is checking to see if Mr. Turner is here. There may have been a miscommunication at the jail. I do know that Mr. Turner has been in medical recently because of, he was part of the unit that was infected with lice and the treatment got in his eyes and burned his corneas. So I know he has been in medical for quite some time related to that. So the deputy went to go see if he was actually transported.
I got you. So Ms. Patton, the sergeant that worked overnight, is that on Ms. Correa's case?
Yes, that's correct.
Okay. So yeah, we'll see. Let's see about that and see if they brought him really quickly.
Yeah. So presuming Mr. Turner is here, it would be him, Mr. Best, and we would need a court reporter for Rivera, but we didn't address position 3, I don't think.
Oh, we got a court reporter. Is the officer here for that case?
Same thing, that I didn't get an indication one way or another. He was subpoenaed. I'd be asking for a one-time reset.
All right, so let's bring Mr. Smith out then while they're checking on Ms. Correa's.
Oh, I know Miss Pinto is still.
Oh yeah, she's still. Okay. All right, well, we'll wait on that one for Ms. Correa's, and then if not, we can take whoever else. And Ms. Watts, I sent you Ms. Chavez's number.
Yes, I called her, Chantel. She's gonna come down to 1A.
Okay, yeah, that's the new person. I didn't have her number.
I have it now. You want me to send it to you?
Sure, that's fine.
Okay.
Your Honor, it seems like he wasn't brought over from the jail. His condition deteriorated and he's being held due to the bed bug and lice infestation.
Right, and I have to assume you don't have permission. You didn't get his permission to waive his presence.
I have permission to waive his presence regarding bond, but not regarding prelim, Your Honor.
Okay. Do you have any idea? Because I mean, I don't. Since Sergeant worked overnight, I don't want to make her keep appearing. How long do you think it needs to be reset for? Any?
I would ask for another, do you know how long the treatment would take or? Because I would ask for possibly to put him on a status calendar for 2 weeks to see if his condition has improved. That way the officer wouldn't have to appear, but I would at least have the opportunity to go back to the jail and speak with him, or at least get a better understanding of what his medical condition, what his medical treatment is.
And then we have another date that we could give the sergeant.
Yes.
How about that, Ms. Patton? Because I don't want to, I mean, I remember how it is to work overnight. I don't want to keep dragging the sergeant back after working overnight.
No objection from the state. I appreciate the concern about having Sergeant keep coming back overnight, because I'm sure it's hard to be
that's
here
fair,
in
and
general.
I also don't want to bring lice and bed bugs into the courthouse.
I would appreciate that.
Gonna be real.
I would appreciate that.
Exactly. So would you want to put her on for the 20, what did we just say? The 20, what was that date?
Yeah, just for, I don't know, just like for status only, just to report, like I'll go back to the jail, or at least have my social worker work with the jail to determine where he is in terms of his treatment. Because I know he was previously treated, which is how he got the treatment in his eyes, had to go to Grady for the issue with his corneas, but it seems like the bugs are still in the jail.
So Sergeant, I don't know if you can hear me. I mean, you probably can't. I don't know if I can hear you. Is there a date? So if we bring this back on just a status, you wouldn't have to come. Is there a date, end of June or July, that you have vacation, or that you're not in training, you're not going to be available?
July, I will be in training for a week. I believe July 16th to the 21st.
Oh,
If you didn't hear her, she said she's in training July 16th to the 21st.
I think that's our PAC conference anyway.
Yeah, and I think, oh, and by the way, Ms. Correa, you could tell the public defender, we're not going to have hearings, what'd I say? 16th, 17th, 18th. We'll have it that Thursday night, but during the day, we won't have prelims or night court so that you folks can attend y'all's training and Pat can attend theirs.
Okay,
So you may want to let folks in your office know. So,
that's good to know because all right, maybe I'll go to mine.
yeah, that way you guys can all go to your training. We'll just do that Thursday night. But so what we'll do is if you want to write that down, Miss Patton, so we would make it maybe do you want us to tentatively put it like the week after that, Miss Correa?
That's fine, Judge. Yeah, the only time that I know that I have actually requested off is just the first week of July.
So, Ms. Watts, what is that next week after July 21st? Maybe we'll put on for the status for June 22nd. Ms. Correa can just report. You can even do that remotely, Ms. Correa.
Yeah.
If you want, just since you're going to give a status on the 22nd. And then for the prelim, we'll reset it to what's the next date in July after that week, Ms. Watts?
We can do July 25th. It's a Tuesday.
Is that okay, Sarge, at 9 a.m.? Did she say yes or no?
That was a yes. Yes.
July 25th at 9 a.m. And I'll write it on here that will remind us too when you get here, okay? That you worked overnight and we'll take you first. And we'll go ahead. We can go ahead and just be heard on bond. And Sarge, if you can go ahead and leave and be safe getting home, we'll just go ahead and hear on bond because you want to be heard, right, Ms. Correa?
Yes, Your Honor.
All right. Thank you, Sarge. Be safe getting home. Stay safe out there. All right. This will be 22 CP.
Thanks for coming back. Thank you.
210000 D'Angelo Turner, 356 days without indictment, 2 counts of willful obstruction of an officer felony, pre-trial.
And defendant has 14 cycles beginning in 2009. Just to be sure, you said this is D'Angelo Turner, right?
Yes, ma'am.
Okay. 14 cycles beginning in 2009. Last arrest was out of Clayton County, November of 2018 for a failure to appear. Underlying charge is battery, family violence. Defendant has a felony conviction out of Lowndes County for forgery in the first 2 counts. I'm sorry, 2 counts in a forgery in the first degree. So you received first offender treatment on that case. Disposition date is December of 2009. Let's see it. Seal date on that is December of 2013. Defendant has 1 additional felony conviction outside of the 10-year period. He has 2 FTAs and 4 violations of probation. And GCIC indicates that there is an active warrant out of Ringgold for a probation violation. Date on that warrant is October of 2019. Nothing to add, Your Honor.
All right. Looks like it's $8,000 good bond as of September the 22nd. Go ahead, Ms. Correa.
Thank you, Your Honor. Mr. Turner is now 33 years old. He has lived in the Metro Atlanta area since 1999. At this stage, he is completely indigent, Your Honor. He would not be able to afford any bond as well as I will be candid with the court, he has lost his housing, but he is a high school graduate. Prior to his incarceration, he was receiving disability due to some older physical injuries as well as his underlying mental health concerns. I'm sure Your Honor can see the filed motions under seal. And as previously stated, he has, at least when I went to go speak with him last week after the first time this was reset, he has been in medical for at least a month at this point. It started out as just a simple lice breakout. He was given the treatment. However, the chemicals related to the treatment did get into his eyes. He did have to be taken to Grady where it caused permanent damage to his eyes and his corneas. And we have reasons to believe that damage is going to be permanent. So we do have concerns related to his physical health as it relates to being in custody, especially since he is still dealing with this infestation. Your Honor reads the news. I know how we all know what's currently going on at the Fulton County Jail. This is a situation where right now his bond would be too high to get our partner organizations involved, but this is a case I would like my social worker to take a look at regarding finding him appropriate housing and treatment for his underlying mental health concerns. I'm asking your honor to consider reducing this bond in half to make that possible.
All right, go ahead, Ms. Patton.
Your Honor, the state would refer to the court's discretion for this defendant.
All right, they should be able to do it at 5,000, right, Ms. Correa?
Yes, your honor.
Okay, so it's 2,500 on each. No drugs unless prescribed, no alcohol, no weapons. No further contact with Officer Braxton Walker or Officer Young unless in their official capacity. Stay away from 5460 Union Hill Court in Union City. We'll have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, and basic life necessities. As long as you supply the name of your employer, proof of employment schedule, the exact location you'll be working. You also have 48 hours to have that ankle monitor placed on your ankle. I'm talking like placed on his ankle, Ms. Correa, after he gets released from any hold. So that'd be 2,500 each charge. And hopefully that will be able to get him out. If for some reason it can't, because we need to get him out of there so he can get treatment, make sure you reach out to Ms. Patton. If they need it lower a little bit more, maybe everybody can consent on that.
All right. Thank you, Judge.
All right, thank you. All right, so that's it. The rest of them, we got officers here, right?
It
Yep.
looks like
Well, we're still missing an officer for position 3.
Oh yeah, Miss
Oh,
Pinto.
but Miss Pinto's not here, but we do have officers here for positions 2, and then we still need a Spanish interpreter for position 8, but 2 is
All right.
here and we're ready to go.
All right, bring out John Michael Best.
Your Honor, I was hoping to talk with Mr. Best before court, but since we had the late, if we could just have like 4 or 5 minutes to talk.
Sure, if you want to step back there, it may be.
That would be preferable, Your Honor. Yes, I'd appreciate that very much.
All right, come on up there, officer. You can take the stand. And we'll go ahead and swear you in, officer. If you raise your right hand, you swear firm testimony you're about to give is the truth, whole truth, nothing but the truth.
I do, Your Honor.
All right, you state your name, spell it for the court reporter.
Officer Robert Stack, Robert. Last name Stack, Stack.
Okay, all right, no worries. So if you just stand by, once he has spoke with Mr. Best to get him out here, we will continue.
Yes, Your Honor. Thank you.
All right. And Ms. Watts did reach out.
The interpreter?
Interpreters, yeah, so hopefully she'll be here soon.
Okay, thank you.
And then on position 3, since Ms. Pinto isn't here, but the officer isn't here either, right?
That's correct, Your Honor.
Okay.
Well, never mind.
All right, let's see.
Oh, interpreter, okay.
Judge Manning,
Uh-huh.
I don't know what to put for the reason for reset on the last case.
Just because he's in medical.
So
Oh,
just
it's
put
correct.
this
Yeah,
in.
because he's in medical.
Okay, thank you.
Yeah, so the 20 seconds is going to be a status where Ms. Correa can report virtually on, if he's out of medical or what's going on, or if he's out altogether. And then we'll
Okay.
have that July date in case we can actually have the prelim.
Okay, thank you.
May I be excused?
Yes, ma'am.
All right, thank you.
Your Honor, the interpreter is here, so as soon as we're done with Officer Stack, we can proceed. I'm ready for the last one too.
Is Ms. Pinto back?
She's not. I keep doing that.
Yeah.
Or I can.
Does she just have prelims in front of
Yes, Your Honor, but it's a co-defendant prelim, which
takes a little bit longer.
offers its fun logistical problems.
All right, yeah, so we'll do this, and then hopefully Ms. Pinto will be finished, and then we can do, and then that would be it, right? Yep.
So Your Honor does have a pretty big
except for-
calendar for 1
Okay.
PM. Would you be amenable if we are going a little over for 30 minutes to break to grab something?
Sure.
Okay. Your Honor, may me and the PD in this case have a brief second to pretrial?
Absolutely.
Thank you.
Thank you, Your Honor. We're actually going to be waiving the preliminary hearing, but we would like to be heard on bond.
Okay, all right, sounds good. Let's see. All right, this officer can be excused, right?
Yep, as far as I'm concerned, yep. Unless the
right.
defense need him.
You don't need him for anything, right, Mr. Cazzoli?
Nothing, Your Honor. Thank you.
All right, thank you, Officer Stack. Thank you for being patient. They worked something out, so we won't need you for bond. Appreciate it. Stay safe
you,
out
Your
there. All right, 22 CP 213487. John Michael Best, 44 days
Bye.
without indictment. We have possession of tools for a crime and theft by taking. Free trial.
Your defendant has 4 arrest cycles beginning in 2016. Defendant has 1 felony conviction out of Bullock County. Let's see, for possession of tools for commission of a crime, criminal attempt to commit a felony, criminal damage to property in the 1st degree, theft by taking, and criminal damage to property in the 2nd degree. Disposition date on that is April of 2017. Let's see, defendant's last arrest was in Fulton County, October of 2022 for a violation of parole. He has 1 additional violation of parole in 2021. And there's nothing to add, Your Honor.
All right, so it looks like there's a $10,000 good bond as of October 27th of last year, right, Mr. Cazzoli?
Yes, Judge.
All right, go ahead.
Thank you, Your Honor. Mr. Best is 53 years old. He has a good address listed on the record. It's 438 Griffin Street Northwest, Atlanta, Georgia, 30318. He's been living there off and on for the last 5 years. He's been in Atlanta for the last 5 years. He has a daughter here as well. He has 8 total children. The 9-year-old lives here, and he has 7 other children over the age of 18 as well. He's a high school graduate. He has been working, before his incarceration, he was working at King and Duke Restaurant. He confirmed to me today that he will be able to return there as well. And he'd been working there for the last 4 years. Your Honor, he was originally arrested in October, was released in November, transferred to DOC to handle his parole violation charges. As he's explained to me, he's all set with that, Your Honor. So this would be the only thing holding him in. We are asking for a reduction to $5,000. Good for the two charges today.
So it looks like the incident location is 441 Griffin Street. That's not so.
Your Honor, that is not his address. I can't speak to how close that is to his address. It does look like it's fairly close. So
Okay.
It appears to be a block away. Your Honor, we would have no issue with it with an ankle monitor. Anything else to keep him at his specific address, though, if that's your concern.
All right, go ahead, Ms. Patton.
Yes, Your Honor. The state would submit to Your Honor's discretion on whether or not to lower a bond and to that amount. We would ask the conditions of an ankle monitor be placed upon the defendant. And I understand that it's a block away, but maybe there's something that we could specify to the specific home in the bond order.
All right. No drugs unless prescribed, no alcohol, no weapons. And so stay away from 441 Griffin Street. Miss Hollenbeck, I guess you could put like, what do you think, 75 yards, Mr. Cazzoli?
Yes.
Okay. If my client's okay with it, I'm okay with it, Your Honor.
All right, yeah, like 7,500 yards, something like that, a football field. That should be enough. No further contact with Avery, Avery, Bartlett, Bartlett, Barlett. Yeah, stay away from 441 Griffin Street. You're gonna have ankle monitor paid for by the county with that 24-hour curfew, court, lawyer, medical, basic life necessities, and employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you're going to be working. So that's 3,000 count one. I'm sorry, 1,000 count one, 3,000 count two. Best of luck to you, sir.
That's fine. I'll work with you. Okay. Thank you, Your Honor. I'm sorry, what was the totals again? It was 1,000, 3,000?
1,000 and 3,000.
Thank you so much, Judge.
Absolutely.
Oh, sure. Your Honor, I did need to speak with Officer Stack really quickly. Is that permittable?
Sure, go ahead. Sure. And Ms. Kennebrew, I guess there's the interpreter if you need to take him back and speak with your client, Mr. Rivera.
I'll get the bond stuff figured out, okay?
I'm back, Judge. I'm ready whenever you are.
Okay.
All right, okay, good. You already have a contact. Okay, all right, excellent, sir. Do you want me to have this? Or, you know what,
So Ms. Kennebrew, I guess if you want to speak with your client really quickly, and then we can bring out Mr. Smith from Ms. Pinto while you're speaking with your client. If you need a second, Ms. Kennebrew.
Yes, Your Honor.
Okay.
take this. Okay, there you go. All right, take care, sir.
LT, if you just want to bring out Blaine Smith
Okay.
from Ms. Pinto.
And Your Honor, may I be excused as well?
Absolutely. Have a good weekend.
Thank you, Judge. And I'll also, just while we're in a little downtime right here, my intern is here. She's gonna be here with me for the summer, Gabby. So if we see you when you're in person, I'll introduce you formally.
Absolutely. Thank you. It's nice to meet you, Ms. Gabby.
Likewise, Your Honor. Thank you.
Hi, Judge.
Hey, Ms. Hollenbeck.
We need a waiver.
Oh, yeah,
from-
Mr. Cazzoli, we need a waiver. There's one up
Yes.
on the bench, Mr. Cazzoli.
On the middle
Yeah,
bench?
it's on the bench. If you're looking at it, it's on the left side, like right there at the top. Sometimes where I keep my code book closest to the witness stand.
This is the.
I'll take a look.
Okay.
Thank you.
Yes, ma'am.
Okay.
You should feel some loose papers up there, Mr. Cazzoli.
I got it, Your Honor. Thank you.
Okay.
Here, I will need 88 patent to sign it, but we should be otherwise set.
Okay. Yeah, she's out there talking to the officer, so. And Ms. Hollenbeck, is somebody going to go get it so they can file it?
Yeah, I'll be down.
Right here, Mr. Smith.
To get
Okay.
it. One.
I'm also happy to submit it electronically if that works.
Oh, yeah, that works.
Oh,
as
okay.
well.
Thank you, Mr.
Thank you.
Cazzoli.
Mr. Cazzoli, when you send it over to the clerk's office, can you CC me on the email as well?
I'm sorry, who said that? Oh, Ms. Watts? Yes, ma'am.
Thank you.
And I assume this is one that I can send to jail unit? Or do I send to motions and entries?
Ms. Hollenbeck.
You can send it to jail unit or motions and entries. It doesn't-
Either one, okay. Good to know.
Thank you.
Mr. Cazzoli?
Yes, ma'am.
Ms. Pinto, once again, I know it's hot in there, so if you have to take your jacket off, I completely understand. It was hot the other day, and I'm sure it hasn't gotten any better.
Thank you, Judge.
I believe it. I don't know, submitted them all. I guess that one never crossed my desk. The birth rate,
I'm sorry.
Yeah, you're welcome. My apologies, Your Honor.
Thank you, Judge.
All right, have a good one. All right, as you can see, Ms. Patton, Ms. Pinto is back, and we've got Mr. Smith out here. So it's 22 CP 214381, 190 days without indictment. There's a $2,500 consent bond as of June the 1st. Criminal damage to property, second degree, and entering an auto or a motor vehicle with intent to commit a theft or a felony. Go ahead, Ms. Patton.
Okay, this is Mr.
Smith, position 3.
Oh, Your Honor, the state is requesting a one-time reset due to the officer not being present. We did subpoena him. We would just be asking for a one-time reset on this case.
So go ahead, Ms. Pinto. I looked at the last reset and it doesn't, which they usually say, it doesn't say why it was reset on the 23rd.
So Judge, I was not here. I was in first appearance that day, but my esteemed colleague, Attorney Kennebrew, covered for me. And I have notes from her. It was reset because the officer was subpoenaed and did not show. And my notes say that it was a one-time reset. It was on May 23rd.
Right.
Mr. Smith has been incarcerated since December 1st of last year, 190 days. He cannot pay bond. There's been no finding of probable cause. We're asking the court to follow the, court's decision. Last time this was set in May for that one-time reset and dismissed for want of prosecution today.
Yeah, I'm not sure why it's not noted on here. And I do believe you as an officer of the court. Ms. Patton, go ahead.
Your Honor, it's up to the court's discretion at this point. I do hear what Ms. Pinto's saying. But I don't know that I have any statutory reasoning beyond that, other than we would simply ask for a reset to see if we can kind of get a hold of this officer.
So this is officer's first initial L as in Lincoln and then last name Smalls. with
Correct.
APD, right?
Correct.
All right. So Ms. Pinto, the same as I think I've offered you before, we can give a straight UJR, and then hopefully if they indict, they won't rearrest him, or we can go with the dismissal. It's absolutely, if you want to ask him, it's your choice. I'd hate for him to get rearrested and sit there for another 190 days, but it's completely, and I understand either way, whichever way you want to do it.
Well, the problem is that he has an entering auto, Judge, and it's my understanding that the court can't set a UJR on that.
Yeah, there is entering auto.
So we would ask for the dismissal.
All right, we'll dismiss for warrant of prosecution. Sir, Ms. Pinto explained it to you. They could still indict you. They could still rearrest you if they did a grand jury. So you just know that, okay? So it hasn't went away, but Ms. Pinto will explain absolutely everything to you, okay?
Yes, ma'am.
All right, best of luck to you, sir. Thank you, Ms. Pinto. And I'll email APD on these. And whenever Ms. Kennebrew is ready, we can bring out Mr. Rivera.
Yep.
How you doing?
Hey.
He's out on bond.
Mhm.
He has a case in New York that he has to go up for.
I will get one more chair.
Make sure he doesn't get in trouble. I'm just trying to get a travel over for him.
Oh, yeah, that's fine.
Literally, he's just gotta go up. Court's on the 12th. He'd be leaving on the 11th.
Yes, ma'am. Have a good evening.
I'll see you tonight.
Thank you.
Ask Judge Manning to sign this. Just wanted to get an ADA, stamp on it first.
So you wanted me to do it?
No, I just want to ask if you have any objection to it, because otherwise we usually have to have a hearing, but if we consult an ADA
So
beforehand.
he's just going to go to court?
Yeah, so he's taking the bus, so he would travel up on the 11th, spend the night, go to court, spend the night, travel back the morning of the.
Fill out
15th.
your copy. Let me take a look. You can take this,
It's
Dan.
a aggravated assault and 2 gun charges, possession of firearm during and possession of firearm by.
Yes, ma'am, Ms. Goodman.
The prelim was.
I was there.
So,
No, you-
officer, if you will raise your right hand for me. You swear a firm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes.
All right, if you state your name, spell it for the court reporter, please.
My name is Sun Tran, first name SON, last name TRAN.
All right, thank you. You can place your hand down. Now, we're gonna have an interpreter out here, so just make sure when you talk, it's kind of in broken sentences, so to speak, just, and keep an eye on the interpreter. She'll let you know if she needs you to slow down or repeat yourself, okay?
Okay.
All right, Madam Interpreter. If you can raise your right hand, Madam Interpreter, you swear or affirm you'll translate from English to Spanish, Spanish to English to the best of your knowledge, skills, and abilities. You guys speak up just as.
I do.
All right, can you spell your name for the court reporter, please?
That's Chantal Hansen, CHANTAL HANSEN. I am a state certified interpreter.
All right. Okay, this is 23 CP 217481. I just did. Hold on one second. Yeah. All right. It's I think it's Eder, EDER Rivera.
Rivera.
65 days without indictment.
5 días sin ser caso enjuiciado.
Entering an automobile with intent to commit a theft or a felony. Possession of Schedule II controlled substance. Possession and use of drug-related objects. Theft by taking. Possession of Schedule II controlled substance.
Sustancia regulada de nivel 2.
And possession of drug-related objects.
También de un artículo o herramienta de.
There are 65 days without indictment.
Tiene 65 días en que el caso ha sido enjuiciado.
And 1 second, there is $17,500 split bond as of April the 6th.
$500 en el depósito de la fianza.
Go ahead, Ms. Patton.
Thank you, Your Honor.
That's yeah.
Hi, Officer Tran. How are you?
I'm good.
Is that your title?
Yes, Officer Tran.
Okay. I'm going to try to go as slow as possible so that we make sure this defendant is aware of everything going on, okay? And I ask that you do the same.
I gotcha.
Where are you currently employed?
with the Georgia Tech Police Department,
con el
And how long have you been employed there?
since August of last year.
desde agosto del año pasado.
Were you employed there?
Ms. Patton, I'm sorry, can you hold on? And I do apologize, Ms. Kennebrew. So the Schedule 2 and one of the drug-related objects, so counts 5 and 6 were previously dismissed because they were
That's
duplicate.
correct.
I apologize. I apologize,
Your
my calendar was off. So just for the record, thank you. Go ahead, Ms. Patton, I apologize.
Sobreseído porque se me equivocaron.
Certainly. Were you employed there on November 1st, 2022?
El
Yes,
1 de
ma'am.
noviembre del 2022, sí,
And how did you become aware of the defendant?
que él,
So we receive a 911 call from the victim,
de la víctima,
and he said that his motorcycle was missing from where he parked it.
auto, estaba estacionado donde la había
And he provided us with the license plate
el número de la
tag
placa
out of California.
y la placa.
And that's when one of my coworker, Officer Dean,
Compañeros, el oficial
stated that she recognized this tag because she was out with an individual earlier that night
estaba afuera
with that motorcycle, same exact description.
esa misma descripción.
Were the plates the same?
Las
Yes,
placas
the
eran
plate
las
was the same.
placas eran las mismas.
So you and Officer Dean
Tal Dean
discussed this.
hablaron
Correct.
sobre este caso. Correcto.
And you stated it was a motorcycle?
Sí, me dijo que era
Yes,
una
ma'am.
motocicleta, sí, señora.
Did you ever have a conversation with the victim?
Conversación con la víctima.
I did.
And what did he indicate to you?
He provided me with the description of the motorcycle, the tag, and he basically stated that he parked it at Montgomery Knight Building, which is inside of Georgia Tech campus. And when he came back to where it was parked, it was missing. So he presumed that somebody stole it from him because we weren't advised that the motorcycle was towed or whatnot.
Repeat the last sentence. You weren't advised that the motorcycle was totaled?
Correct. It was not towed.
Okay. Did, I think he's saying
Like
towed.
impound?
I'm sorry, I'm gonna try to see if I can zero this in as much as possible. Okay, did the victim at any time, Mr. Henderson, indicate to you that he had given permission for anyone to use his motorcycle, move his motorcycle?
No, not at all.
Did he state that he had given, and I'm not certain if it has a key, but did he state that he had given a key to anyone for the motorcycle?
No.
Okay, so let's go forward a little bit. So you said you spoke to Officer Dean, and is that a male or female officer?
She's a female officer.
Okay, and she said she saw someone with that same yellow bike.
That's correct.
Okay. Did she indicate who she had seen with the bike?
She advised it was a Hispanic male.
Is that all she told you about the description of him?
She gave me clothing descriptions and whatnot, and she advised that she was out on the individual because she thought it was odd that he was pushing the motorcycle. And so she tried to go out and assist him, see if he needed any help.
You mean physically pushing the motorcycle?
Physically pushing the motorcycle.
Did she indicate whether the motorcycle was on at that time or if it was just?
So the motorcycle wasn't on and he was just pushing it. She couldn't communicate with the defendant because there was a language barrier.
So she advised you that there was a language barrier between her and the defendant?
Correct.
Okay. Did she get any indication as to why he was pushing this bike?
I don't remember.
You can take a look at your warrant.
Okay, yeah, so earlier in the call, we have another, our lieutenant, which is our supervisor, Lieutenant Ortiz came out and he was a Spanish-speaking officer and he was able to help with the language barrier. And the defendant advised Officer Dean that he was trying to push the vehicle or the motorcycle. And Officer Dean basically stated, okay, I can assist you by calling a tow company if something is, I guess, mechanically wrong with your motorcycle. And that's the extent of the interaction that she had with the defendant.
Did he wait around for a tow company? Do you know if he waited around or if he left?
I'm not too sure. I know that Officer Dean left the location. She did call a tow truck for him. But when I was patrolling, I did not see him at that intersection of 10th and Northside or near 10th and Northside.
Okay. Did you ever follow up with the tow trucking company to see if they actually came out?
No.
So, your timeline is we have Officer Dean seeing a Hispanic male pushing a yellow motorcycle. She offers to get it towed. And then later on, you guys received a call from Jack Henderson saying that his motorcycle had been stolen.
Correct. And he basically gave the exact description of the motorcycle that Officer Dean came across because it's very distinct.
Okay. Do you remember what type of motorcycle it was?
It was a yellow Honda motorcycle with specifically the California tag.
Okay. So at that point, after Mr. Henderson had informed you about his motorcycle, what did you do next?
So we knew that the defendant was pushing this motorcycle, so we figured he probably wasn't pushing it far. So we basically cast a big perimeter to canvass the area to look for the individual with the motorcycle.
And did you find the motorcycle?
Yes. So my other partner, Officer Massey, he was able to locate the distinct motorcycle with the Hispanic male, which is the defendant, at which point he made contact and detained him.
Did Officer Massey ever investigate the motorcycle?
Yeah, so he came over radio and he advised that the motorcycle was indeed, it has the same California tag that the victim stated. And so we, put one and one together and came to the conclusion that is Mr. Henderson's motorcycle.
Okay. Did you guys ever do a VIN check?
A VIN check? I do not recall.
Okay. So once Officer Massey, you said, detained the defendant on suspicion because of the bike, that this was the bike, and he investigated the bike and he confirmed that it was the bike. Did he ever speak to the defendant?
So after we confirmed that it is the victim's motorcycle, the defendant was placed into custody, at which point he is now arrested. And further investigation, search to incident arrest, Officer Massey located suspected meth on the defendant's person and also a clear pipe, commonly known as a crack pipe, that are used to cook up the meth.
Okay. You said he was searched incident to arrest. Did you ever issue him any, or not you, I'm sorry. Do you know if Officer Massey issued any Miranda warnings?
I'm sorry, I do not recall.
That's fine. Do you know if Officer Massey's body cam was on at the time or dash cam?
It should be. It should be.
You don't have personal knowledge, but you're saying it should.
Correct.
Okay. Would that have been submitted for evidence?
Yes, all of our videos are, it's all documented. and listed for evidence, all of our video.
Do you have personal knowledge that this video was submitted?
It should.
Okay, so it's policy to submit it.
Correct.
Okay, but you don't have actual personal knowledge.
Correct.
Okay. So, Officer Massey searched the defendant incident to arrest, and you said he found I think you described it as a cracked glass pipe and possible methamphetamine.
Yes.
Was this possible methamphetamine, ever sent for testing?
So, yes, it did get sent to GBI. We also have a test kit at our precinct. Officer Massey confiscated the drug, the possible drug, and we bring it back to the precinct, test it for methamphetamine, and it was test positive for that scheduled drug.
So tell me about the testing kit that you guys have.
It's basically a tube. It takes a sample, and there's some type of liquid substance that would pour into that sample, and it will help us identify if it's positive or negative for the scheduled drugs.
At any time, did you have the victim confirm the defendant?
Like his identity?
Yes.
Yes, I believe so, but that was done with other units.
But you do know that it was done?
Yes, and we was able to positively identify the defendant.
Do you know if it was done through a photo lineup?
If I remember correctly, we identify him, I believe, with a fingerprint scanner. Or he might have had an ID on his person, but I remember we was able to positively identify him.
Okay. Do you know if there was video surveillance of the incident?
I'm not too sure.
Okay. Do you know if Mr. Henderson, the victim, ever stated to the defendant that he was free to touch the motorcycle and leave fingerprints all over it?
No.
Do you know if Mr. Henderson had any knowledge of the defendant?
No.
Do you see the defendant who was arrested in this case in the courtroom?
All right, everybody can remove their masks.
Yep.
Your mask.
Yep.
Can you please identify him with an article of clothing?
You can
He's
stand up if
wearing,
you need to, officer.
excuse me, ma'am?
If you need to stand up, you can.
Oh, I'm looking through the camera.
Oh, okay, there you go.
Yeah. He's wearing a blue outfit with a white shirt. He has a beard and a black face mask with a low haircut.
Is he to my left or to my right?
He's to your right.
Let the record reflect that the witness has identified the defendant.
All right, record shall reflect.
What happened to the motorcycle after Officer Massey located it and then subsequently detained the defendant?
The motorcycle was released to the owner, the proper owner, which is the victim, and we have him sign a property release form before we hand his motorcycle back to him.
So he confirmed that this was his bike?
That is correct.
Okay, and he, going back a little bit, you stated he gave the defendant no permission to to have his bike or to take his bike or anything.
Been asked and answered.
I'll withdraw.
Thank you.
Are you post-certified?
Yes, ma'am.
Were you post-certified at the time of this incident?
Yes, ma'am.
Antes de este incidente, sí.
Now, I honestly can't remember. Did you say Officer Massey spoke to the defendant?
He tried to, but there's a language barrier.
Was he able to get any kind of communication?
Our lieutenant did come out a second time to translate, but at which point the defendant was not being cooperative with trying to communicate with my lieutenant, who was trying to, get more information from him.
What do you mean, not cooperative?
I was assuming that he was just kind of like speaking gibberish, or maybe he was.
Objection, speculation. He said he's assuming.
Yeah, can't assume.
Yeah, sorry. I don't know what he said. He spoke Spanish.
Okay. You don't speak Spanish?
No, ma'am.
Okay. Did Officer Massey ever indicate to you that, or where he found the alleged methamphetamine on the defendant?
No, ma'am.
Did he ever indicate to you whether he manipulated it in any way, like touched it or?
No, ma'am. I don't recall.
Okay. Do you know if the methamphetamine was tested there, or was it tested back? I think you said you had to test at the
precinct.
Uh-huh.
Objection, asked and answered.
He's asking answered about the positive test.
Mm-hmm. Okay, I'll move on. Nothing further at this time.
All right, Cross?
Yes, Your Honor, thank you. Good morning, Officer Tran.
Good morning.
All right, so you were dispatched to the incident address on a theft call, is that correct?
That's correct.
And when you arrived, who did you initially speak with?
I spoke to the victim, Mr. Henderson.
And did you have on your body worn camera at that time?
Yes.
And did you preserve your video from your body worn camera?
Yes.
And did the alleged victim state that they saw who took his motorcycle?
No.
And were there cameras at the incident location that captured the alleged incident?
I don't recall.
And can you say again where the, actually strike that. When you approached my client, what was his demeanor?
The defendant was in handcuffs.
So when you initially saw him, he was in handcuffs?
Correct, because Officer Massey was the one to detain him.
So in your report and on direct, you stated that Officer Dean spoke to a Hispanic male earlier who was pushing a motorcycle. Is that correct?
Correct.
And when the report came in of an alleged theft, she stated that she recalled seeing a Hispanic male pushing a motorcycle, correct? The same motorcycle, excuse me, the same motorcycle, correct?
She said that, so when I gave the California tag over the air, over the radio, that's when she said, oh, I've dealt with this motorcycle with this same California tag.
Okay, and did she state how she was aware of that tag?
So she, when she went out with the defendant initially, it's common practice for us to, if it's a vehicle, a motorcycle, we'll put it over radio. Kind of help us keep track in case if something, very specific, something like this ever to occur, we'll have record of what kind of vehicle we were out with.
So to be clear, you said you put it over radio. Does that mean that you read the tag over the radio so that they're aware of what the tag is?
Yeah, Officer Dean would put it over radio, and then the dispatch would put it in the basically the system's notes for records if we were to pull up that call again.
So that is a way to, again, keep track of the license plate number.
Correct.
That license plate number would have been in the notes that the other person took down.
It should be.
Okay. And once you guys were aware of the license plate number given by the alleged victim, did you cross-reference that license plate with the one that she had taken down earlier?
Yeah, so Officer Dean was the one that made us aware. And she said, hey, listen, guys, I was out with that California tag earlier. And that's when we go back to the call notes and it matched with the tag that she gave us by what the victim provided.
So you did go back to the call notes?
Yes.
Thank you.
She did.
Okay. Did anyone see my client riding or driving the motorcycle?
He was pushing it. He wasn't riding it.
So is that a no to riding or driving the motorcycle?
Right, correct.
Okay. And when Officer Dean spoke with the Hispanic male, they told her they told her that the motorcycle had broken down. Is that correct?
I believe so.
And there was a towing company that was called, correct?
Yes.
Did the Hispanic male decline a towing company being called? Are you aware?
No, I'm not aware. That's gonna have to be Officer Dean. She'll know more detail of that interaction.
Okay, thank you. Was the motorcycle ever towed?
I don't believe so. It was not, I know it was not towed on campus where the original incident occurred.
Now, do you know the time between Officer Dean seeing the Hispanic male pushing the motorcycle and then getting a call about a missing motorcycle?
So I do remember that Officer Dean came in contact with the defendant before midnight. Which should be October 31st. And then I received the call November 1st, which is after midnight. I do remember that.
But no specific time frame.
It should be under the call notes, but I just don't recall the exact time frame.
Okay. Now, did the alleged victim provide a vehicle registration or any documentation showing he was the legal owner of the motorcycle?
I don't recall.
Did the owner ride off on the motorcycle or provide any keys to start the motorcycle in front of officers?
He did have the keys.
And did he start the vehicle in front of officers?
That's correct.
I'm sorry?
Yes, ma'am.
And so my client was arrested and he was searched incident to arrest, correct?
Yes, ma'am.
And it was stated that methamphetamine was found, correct?
Yes, at the time it was possible methamphetamine.
Okay, and so the possible methamphetamine, are you aware of where that methamphetamine was found or was located?
I'm not sure. Officer Massey was the one that conducted the search.
And the drugs were sent to the GBI, correct?
It should be. That case was a team effort. So I believe Officer Massey was the one that should have sent it to GBI.
And are you aware, or did you check before today to see if the results had come back?
No, I did not.
And you stated that you believe that my client was identified on direct. Are you personally aware that he was actually identified?
I just remembered that my coworkers provided me with his information.
And were there any other witnesses there that saw the alleged incident?
I do not believe so.
And was there anybody there that actually saw my client take or ride off on the motorcycle?
Not from the original incident location. No, I don't think so.
Can I have a moment, Your Honor?
Yes.
No further questions, Your Honor.
Anything else from the state?
Yep. You just talked to Ms. Kinnebrew about the ID of the defendant. Did Officer Dean ever indicate that she had seen the defendant and in terms of how they ID'd him?
I don't remember.
You don't remember? That's fine. Nothing further from the state.
All right, anything else from the defense?
No, Your Honor.
All right, this officer can be excused, right?
Yes, Your Honor.
All right, stay safe out there, officer, and thank you for being patient.
All right, thank you, Your Honor.
All right, go ahead with argument.
Yes, Your Honor. Can I have one moment?
Absolutely.
You need me to sign something? Oh, no, I'm good. That was just a copy. Thank you. Thank you for coming out.
Your Honor, we would be asking that no PC be found on the entering auto. There was no testimony that my client entered a vehicle or even rode on top of the motorcycle. There was no testimony or any information inside of the warrant that he actually reached into a compartment or a saddlebag or anything on that actual motorcycle. So we would be asking that there is no PC on the entering auto, and we would submit to the testimony on the other charges, Your Honor.
All right, what says the state?
Your Honor, the state would ask that you do find PC on the entering auto. I was looking at the entering auto statute, and because it is a motorcycle, the act of pushing it, I understand that you're not opening a door, but to even push it, you have to get over it, which we would believe qualifies as an entering to satisfy the entering auto. There's been testimony regarding the fact that this motorcycle was not the defendant's, that it similarly matched in license plate and color motorcycle that had been, am I going too fast? I'm sorry. That had been reported stolen and thus did not belong to the defendant. We would ask that you find PC, as stated before. Probable cause is, more likely than not, it's a relatively low standard to meet, and we believe the state has met that burden.
All right. I'll find probable cause on both. There is a $17,500 good bond. Wow.
Your Honor, defendant has 3 arrest cycles beginning in 2006. He has no felony convictions. And his last arrest was August of 2022 out of Hateville for disorderly conduct and driving without a valid license. No dispositions listed. Nothing to add, Your Honor.
Go ahead, Ms. Kinnebrew.
Yes, Your Honor. Mr. Rivera is 39 years of age. He does have a address in the Hayfield area. He has been a resident of Georgia for the past 23 years. He is the proud father of 3 children. He is currently married and has been married for 15 blissful years. He does have family here in Georgia, including his wife as well as his children. He did graduate from high school. He is employed. He does home renovation, landscaping, and he's a mechanic. We're asking for the bond to be reduced to a $5,000 bond, Your Honor. He has been in custody for 65 days. He is indigent and he is presumed innocent. He cannot afford a bail as he hasn't been able to post bail within the last 65 days. So again, we're asking for the bond to be set at $5,000. And we are reminding the court that the purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of the person in court for trial. He has never been convicted of felonies. Oh, I'm sorry.
Sorry.
Which part did you need?
We all just kind of get our stride there.
I know. Okay, so he has never been convicted of any felonies as stated by pretrial. So again, we're just asking for a $5,000 bond to be set so that my client can fight his case from outside.
All right, what says the state?
State would submit to the court's discretion.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay off all Georgia Tech properties or anything that says Georgia Tech. Reminding you, all Georgia Tech property is not there on campus. So anything that belongs to Georgia Tech, stay away from it. Stay away from 270 First, FERST Drive. No further contact with Jack Henderson. Stay away from 468 Joseph E. Boone Boulevard. I think I've already said I lost track. No drugs unless prescribed, no alcohol, no weapons. Have an ankle monitor paid for by the county. With a 24-hour curfew, with the exception of court, lawyer, medical appointments, employment, as long as he supplies the name of his employer, proof of employment, schedule, and the exact location he's going to be working. And Madam Interpreter, understand he may be self-employed, so he has to report like a job site he's going to, what time he'll be there, what time he'll leave, and also basic life necessities. 3,000 on count 1, 8,000 on count 2. Best of luck to you, sir. And then the other ones will stay UJR through the jail. They're on level 2 pretrial, but just go ahead and make them through the jail.
Thank you, Your Honor.
They're UJR through the jail. Best of luck to you, sir.
Your Honor, you did say no drugs without legal prescription?
Yes, ma'am.
Okay.
Anything else, Ms. Hillenbeck? Ms. Hollenbeck, you need me?
No, that's it.
All right, can you make up some of those that we reset because an officer didn't appear? Just make sure it says officer no show and one time reset only.
Okay.
All right. Thank y'all. We'll see y'all back at 1 p.m. Thank you, Ms. Kennebrew. Thank you, Ms. Patton.
Thank you.
Thank you.
Thank you, Ms. Goodman. See y'all at 1.
Mr. Lang, I took a look.